Hi, everyone. My name is John Tycko, and I am going to be your host today. I'm going to start just by introducing myself really briefly, and then we will dive into the presentation. So, again, I'm John Tycko. I'm one of the founding partners at the law firm of Tycko and Zavari LLP. We are a law firm with offices in Washington, D.C., and in California. And I am a practicing litigator. I've been doing this for about 30 years. And for about the last 15 years, my practice has focused heavily on representing whistleblowers in key TAM litigation, which is something we're going to talk about and explain today. And I've represented parties in probably more than 50 of these cases all across the country. And many of them have involved fraud on the customs system, which is what we're going to be talking about today. So I hope you find this interesting. And if you have any questions as I go along, please do ask them. We will have an opportunity for some Q&A at the end. And I'm going to start now by sharing the slideshow. And at the end of the slideshow, I'll come back live and answer all of your questions. All right, so here's just kind of the rules of the road for today. You're all muted, so I won't be able to hear what you say, although you can type your questions into the comments, and then I will answer them at the end of the slideshow. You'll be able to see this replayed on our law firm's LinkedIn page. And I will provide my personal contact information at the end. So if there are questions that you want to ask later, or you want to ask questions about specific situations that we won't really cover in the sort of public session today, you can reach out to me. I'll provide both my phone number and my email address as ways to get in touch with me. So let's dive into it. These are the topics that we are going to cover today. A quick introduction to the False Claims Act. And we're going to talk about the common types of customs evasion that might violate the False Claims Act. We're going to talk about what a key TAM action is and what makes those actions special, and how you earn rewards for bringing one of these cases. There are very, very substantial monetary rewards, and I'll be explaining how that works and giving you some statistics about awards that have actually been awarded. Talk briefly about the anti-retaliation provision of the False Claims Act, and then about e-allegations and EPA claims. That's the Enforce and Protect Act. These are other ways other than the False Claims Act for blowing the whistle on customs fraud, and I'll be explaining those and giving kind of the pros and cons of taking those alternative paths. And then we will dive into your questions. So I'm going to try to do the slideshow fairly quickly so that we leave time to answer questions at the end. All right, so here we go. So, what is the False Claims Act? The False Claims Act is the primary statute that makes it illegal to commit financial fraud on the government. And it primarily covers what are called false claims, which are requests to the government to be paid money by the government that are false or fraudulent. But the False Claims Act also has what's called the reverse false claims provision, and that's the language that you see on the screen right here. And the reverse false claims provision makes it illegal to basically, through deception, avoid making payments that you owe to the government. And there are two primary elements that you have to take into account here. First, there has to be a false record or statement. So there does have to be an actual false statement made in a document that goes to the US government. And then the falsity has to be knowing. Um, and each of these sort of terms have technical meanings under the False Claims Act. And the first thing I'm going to talk about is, what does it mean for the falsity to be knowing? So imagine a situation where an importer has imported a product into the United States, but they've lied, or let's not use the word lied. They have made a false statement to the government about what products they are importing into the United States. When would that false statement be knowing? Well, most people would think of the word knowing as meaning that you actually know that the products you're bringing into the United States are something different. But in fact, this term has a special meaning under the False Claims Act. And it doesn't just mean that you actually know, it also means sort of that you should have known. And that's what's meant here by deliberate ignorance of the truth or reckless disregard for the truth. And in the customs realm, what this means is that importers have some obligation to make sure that the information they provide to the government in connection with their imports is accurate. And it's not enough to just put your head in the sand and remain ignorant. If you should have known that the products were something other than you claimed, or you should have known that the country of origin of those products were something other than what you claimed, then you might be liable under the False Claims Act. And the false statements in customs cases are almost always made on what is known as the Form 7501. For those of you who actually live in the world of international trade, you're very familiar with this document. Anytime products are imported into the United States, the importer has to give the government one of these forms, either the actual form or an electronic version through what's called the ACE system. But I've highlighted on this image some of the key elements of this form that often become the false statements that give rise to liability under the False Claims Act. So the form, for example, asks, what is the country of origin of the goods that you're importing into the United States? It asks for a description of those products. It asks for what is known as the US code. That's the harmonized tariff schedule of the United States. It asks you to provide that number, which is a key number that allows the government to determine how much is owed in terms of duties. And then you also have to tell the government how much quantity and the value of the goods. And the value, of course, is important to customs and tariffs because typically duties are calculated as a percentage of value. So these are the sort of the fields on this form that typically give rise to False Claims Act cases, because these are the fields where the false statements or the false information are provided to the government by the importer. Now, what are some sort of typical types of customs evasion that we see in False Claims Act cases? Well, I'm going to start with talking about what I call punitive tariffs. And these are tariffs, usually very high duty rates, that are typically imposed by the government on particular products with particular countries of origin. And so there are a number of different ways that this can happen. Probably the two most significant right now, at least, are what are known as anti dumping and countervailing duty orders. These are orders that are imposed, again, on particular products with particular countries of origin that often have very, very high duty rates. And then there are what are known as the Section 301 tariffs. These are the tariffs right now that apply to the vast majority of goods that are made in China. They were first imposed back in 2018 during the Trump administration. The Biden administration has kept these tariffs in place, and in fact, is in the process of raising the Section 301 tariffs on certain goods. So these are here to stay. And so because these punitive tariffs apply to a particular product from a particular country, there are sort of two obvious ways that an importer could commit fraud, either lying about the product, the nature of the good, which will usually take the form of a misclassification of the product under the harmonized tariff schedule, or making false statements about the country of origin. And false statements about the country of origin are very frequently accompanied by transshipment, which is moving the products out of the actual country of origin through a third country and then to the United States, claiming that that third country is actually the country of origin. And that transshipment is sometimes accompanied by a claim by the importer or the manufacturer of the products that there has been some what is called substantial transformation in the third country. But often we find in the cases that we bring under the False Claims Act that these claims of substantial transformation are not really true. or don't really hold up to scrutiny, that there is no actual substantial transformation occurring in that third country, and that in fact the country of origin is something other than is being claimed by the importer on the Form 7501. And then with respect to pretty much any kind of duty, so this is not just the punitive tariffs, but just duties that apply generally to goods, there are other ways in which importers can violate the False Claims Act. One is just by falsifying the value or quantity of the goods that are being imported. When this is done intentionally, we often see what are called double invoicing schemes, where the customer in the United States is paying one price for the product that they're importing, but they submit an invoice to CBP in connection with their 7501 showing a lower price, a lower value on the goods, a sort of a false second invoice. And then there's failure to include what are called assists in calculating the value. So an example of an assist might be, let's say I'm importing into the United States a product that is manufactured in Vietnam. And part of that manufacturing process is that I've actually provided to the Vietnamese factory some component. When I import that product, the fully manufactured product into the United States, the value of that component that I've provided has to be included in the value of the product for purposes of calculating the duties owed, even though you're not paying that price to the Vietnamese factory. So that's called an assist. That can happen in various ways, and cases have been brought under the False Claims Act for failing to include assists in the values claimed on the 7501s. And then finally, there's what is called structuring. And this is when a single transaction is split up into multiple smaller shipments, each of which is underneath what is called the de minimis value. It's currently $800, which is considered duty free. So by taking one big transaction and breaking it up into $800 smaller transactions, an attempt can be made to evade the payment of duties. And when that's done intentionally, that's called structuring and is considered a form of customs fraud. Let me back up here a little bit. Okay, and then there's one other type of claim that can be brought under the False Claims Act, and this relates not so much to the statements that are made in the entry documents in the 7501, but to the actual country of origin marking of the product itself. So U.S. law requires that imported products be marked accurately with their country of origin. And if an importer imports products into the United States that are not marked with their country of origin or are marked with a false country of origin, and those products actually make it across the border into the stream of commerce in the United States, then the importer becomes liable for what is known as marking duties. This is an extra 10% duty. And again, if this is done knowingly, again, as that term is defined under the False Claims Act, so not actual knowledge, but hey, you should have known, then the importer can be liable for those marking duties in a False Claims Act lawsuit. The case that established that, I give the citation there. It was a case back from 2016. That was actually a case that I worked on with others at my firm. And this was the first case that established that country of origin marking is something that is actually covered by the False Claims Act. So now let me turn to what is a qui tam case. How does a private citizen actually bring one of these cases? So the term qui tam is derived from this long Latin phrase that we've put up there on the screen, and it basically translates into an action brought by a private citizen, but on behalf of the government. So when you bring a qui tam case, you are the party initiating the case, but you are trying to recover money that is owed not to you, but to the government. And the vast majority of the money that you are able to recover through that lawsuit will in fact go to the government. Although we'll talk about rewards, the amount that goes to the person who brought the case in a little bit. The person who brings the qui tam case is called a relator. Now, we often use the word whistleblower, but that's not actually the technical term under the law. The technical term is a relator. The government is considered a party in interest, and government lawyers at the Department of Justice will be assigned to your case to monitor it and to do certain things on the case, which we'll talk about in a little while. So, who can bring a key TAM case? Like I said, we use the term whistleblower, but that's not the technical term. And in fact, when most people think of whistleblowers, what they're thinking of is an insider, somebody who's inside the company that is committing the wrongdoing or inside the conspiracy to commit the wrongdoing, who then discloses that wrongdoing. But in fact, the False Claims Act is not limited to those sort of traditional whistleblowers. So, first off, a relator, again, that's the technical term for the party bringing the False Claims Act key TAM case. The relator can be either a natural person, an actual human being like you or me, or it can be a business entity, a corporate entity like a corporation or an LLC. It can be a traditional insider whistleblower, but it doesn't have to be. There are many cases, particularly in the customs realm, that are brought by outsiders to the company that is the target of the case. And these could be industry experts, people who have just learned about the fraud through some other channel, or people that have even done their own investigation and analysis of data or other information that is out there to try to prove that this fraud is occurring. Now, I have to say, for outside whistleblowers, there is one trap in the False Claims Act, and that's known as the public disclosure bar. So the law says that key TAM cases cannot be based upon publicly disclosed information. And that's a sort of a technical meaning under the statute, what counts as a public disclosure. But the simplest example I can give is if you read about a fraud, say in the newspaper, or you hear about it on TV or on a website, you can't then turn around and file a key TAM case based upon that fraud that you learned about from news media. Okay. But raw data, raw unanalyzed data is generally not considered a public disclosure, which is how data mining is often used to develop or at least to support successful key TAM cases. In the customs realm, key TAM cases are often brought by competitors. There may be a domestic US based company that believes that one of its competitors is importing competing products into the United States while evading tariffs, trying to keep their costs down through that illegal evasion. And so the competing company can bring a key TAM case as a way to bring that to the government's attention and to potentially get some recourse. And then sometimes domestic industry groups, trade associations have been relators in key TAM cases, particularly in the anti-dumping, countervailing duty realm, because those trade associations are often the entities that initiate the administrative proceedings that lead to those AD/CVD orders. And then once they get those orders, they're then monitoring the market to make sure that people are complying with them. And if they see a company that is evading the AD/CVD order, they may bring a key TAM case as a way to remedy that evasion. So there's lots of different types of people and entities that can bring key TAM cases under the False Claims Act in the customs realm. And all of these different types of people and entities have, in fact, done this and had success doing it. So, key TAM actions are a little bit different than normal lawsuits. Typically, if you sue somebody in court, you file a complaint, and right away you have to serve that complaint on the defendant so that the defendant knows that they've been sued and have a chance to defend themselves. Well, in key TAM actions, the statute specifically prohibits you from doing that. And in fact, the way it works is that the complaint is filed in court, but it is filed what we call under seal. That means that it's a secret filing. It's not part of the court's public docket. It's not known to the public. And if somebody goes and tries to search for it, either at the courthouse or electronically through the public docketing system, which is called PACER, they won't find the key TAM case that's been filed because that case is under seal, at least for some period of time. The initial seal period that is provided by the statute is 60 days, but those are typically extended at the request of the government. And the average time period during which a newly filed qui tam case will remain under seal is about a year and a half, 18 months, although it can be quite a bit longer than that in particular cases. The seal is there to protect the government's investigation, because when you file your qui tam case under seal, while you don't serve it on the defendant, you do serve it on the Department of Justice. And the government opens an investigation of your case. They treat it basically as a tip. And in customs cases, they will work with lawyers and investigators at the Department of Homeland Security, which is the agency of which CBP is a part, to investigate that claim that you're making that somebody is engaged in duty evasion. And the case will remain under seal until the government is done with its investigation. It's there to keep the investigation secret so the defendant doesn't destroy evidence or bribe witnesses or any of these things that defendants might do if they were tipped off to the presence of a government investigation. And the seal is important to the relator. If the relator breaks the seal, you may lose your chance to get a reward, or you may even have your case dismissed. And then once the government sort of completes its investigation, there are a number of different steps the government can take. If the government wants to pursue the claim on its own, then it does what's called an intervention. It basically comes in, it tells the court, we are intervening in the case. The Department of Justice lawyers become the lead lawyers in the case, and the government basically steps into the shoes of the relator in pursuing that litigation. The government can also decline the case. And if the government declines intervention, then the relator, the party that brought the case, has the option to pursue the case with its own lawyers or with their own lawyers. And it then just becomes a normal piece of civil litigation. At either intervention or declination, that's when the seal is lifted. The case becomes public. The defendant is then told about the case. They do have a right to defend themselves, and the case proceeds like normal litigation at that point. As a practical matter, in cases in which the government is going to intervene when they've decided that that's the step they're going to take, they will almost always approach the defendant company and try to work out a settlement. And normally in those cases, the defendants do settle, because by then the government has already done its investigation. It already has the goods. They know that they've been caught, and they often settle. The Department of Justice also has the option to dismiss the case, and they can dismiss the case even over the relator's objection. That doesn't happen frequently, but it is an option. It's usually done in cases where the government has some other reason for wanting the case to not go forward, or where they've affirmatively concluded that the relator is wrong, or that the relator has some ulterior motive for pursuing the case that the government doesn't like. But like I said, that doesn't happen very frequently, but it is an option. So one of the things that makes the False Claims Act so powerful, and qui tam cases so powerful, is that the statute provides for very strong remedies. So it's not just the amount of money that the defendant has failed to pay in duties. It's treble damages. It's 3 times that amount, plus a civil penalty for each false statement. So in that case, that would in a customs case, that would typically be for each Form 7501. So I've given just a simple example here with some simple math. Imagine a company has evaded $2 million in duties that it hasn't paid. They get caught, they get sued under the False Claims Act. The False Claims Act provides that that company could be liable for treble damages, $6 million, plus penalties of, between roughly $14,000 and $28,000 per false claim. So in my example here, I'm assuming $2 million in duties owed across 25 shipments. So they would be liable for 25 separate penalties. So you see how a $2 million fraud results in around $6.5 million in liability to that company. The numbers get very big, very fast. And those numbers then translate into very large monetary rewards for relators. So here is how that works. If the government intervenes, then the relator's share, that's what it's called under the statute, but that's the reward we're talking about. The relator's share, or the relator's award, will be somewhere between 15 and 25% of the money that the government recovers. So imagine that example where the government's going to recover $6.5 million. Well, 15% of that is $925,000. 25% of that is about $1.6 million. So that's the amount that is going to go to the relator as the relator's share. If the government declines intervention and the relator then pursues the case on their own and makes a recovery, then the relator's share automatically goes up to 25 to 30%. Again, just, based on my hypothetical, 30% of 6.5 million is almost 2 million. So the relators do in fact stand to earn these very large rewards. And this is, intentional under the statute. The statute was designed to encourage people to come forward and disclose violations to the government. Customs fraud in particular is often very, very difficult for the government to detect on its own. The government relies heavily on whistleblowers and relators in key TAM cases to notify the government of the existence of the fraud in the first place. And so these financial incentives are there intentionally to encourage people to come forward when they know that there is customs evasion occurring. The statute always also provides for shifting of attorneys' fees and other expenses. So a successful relator should be made whole in that respect as well. If you have to incur any expenses in investigating or pursuing the case, or you have to pay your attorneys any money, the defendant company would have to reimburse you for those expenses as well. Although I will say that most lawyers who represent relators in these cases do so on a contingency fee basis, which means that they are just paid a percentage of your recovery. So you may not be out of pocket attorney's fees, but if you were, you would be able to recover those under this provision of the False Claims Act. So you might ask, does the government actually pay these types of rewards? And the answer is they absolutely do. Under the False Claims Act, the government typically pays out well in excess of $100 million every year to relators. And I've just compiled some statistics here. This is just customs cases. So between 2011 and 2023, the government settled 43 False Claims Act cases alleging customs evasion. 42 of those 43 were brought by relators as key TAM cases. So you'll see that that's just a huge percentage. These cases wouldn't be brought at all if it wasn't for whistleblowers and other types of relators. In those cases, the government itself recovered more than $220 million, and it paid more than $20 million in rewards to relators for an average relator award of around $550,000. That's about 18% on average. Now, this is backwards looking statistics. If I had to predict, I would say that these numbers are going to go up dramatically over the coming years. And that's because the nature of the trade wars has changed. There was a time period prior to 2018 when, for the most part, duty rates were low. And outside of a few anti-dumping cases, there wasn't much reason to engage in customs evasion. But now we are in an era of trade protectionism and trade wars. The tariff and duty regime in the United States covers many more products and at much higher duty rates. And because of that, there is significantly more incentive to engage in customs evasion. And we know statistically that this occurs particularly with products that are made in China, and where the importers or the manufacturer of those products in China or the importers in the United States are trying to evade the Section 301 tariffs or the anti-dumping tariffs. And so there's quite a bit more customs evasion occurring now than there was, say, 5 years ago. These cases take a number of years, so we're just now starting to see the results of key TAM cases that were brought in the past. And going forward, these numbers are going to just skyrocket because there's so much more customs evasion going on, so much more opportunity and incentive to engage in customs evasion. And hopefully that will result in more enforcement And a big part of that, obviously, is enforcement under the False Claims Act through key TAM cases. Now, in addition to providing monetary rewards to relators, the statute also offers some affirmative protections, particularly in cases where you have a traditional insider relator, somebody who works at the company or works for the company that is engaged in the customs evasion. In that situation, if the company engages in some kind of workplace related retaliation, they fire the whistleblower, they demote the whistleblower, they isolate the whistleblower and don't give the whistleblower any chances for advancement, um, then the whistleblower would have a claim for their own personal damages for that workplace retaliation. These we call these Section H claims because it's subsection H of this provision of the False Claims Act. And this slide, that's literally the language from the statute, so you can see what it is. But this, offers some protection to whistleblowers, again, traditional insider whistleblowers who are thinking about blowing the whistle. If they do that, if they report the wrongdoing to the government, they are protected by this statute. And if their employer were to take some sort of retaliatory action towards them, the employee would then have an individual cause of action against their employer for that to recover their own damages. And that would be on top of whatever reward they got for bringing the key TAM case. Now, the False Claims Act is not the only way that you can blow the whistle on customs evasion. There are sort of two other paths. The first is what we normally call e-allegations, or more technically, moiety claims, which are based on this statute and regulation that is on the slide there. That is a very, very simple procedure. CBP has a website that you go to, and they ask some questions about who you are and who the parties are that are involved in the evasion and what evidence you have. And you fill out that form and you submit it through the website. And if you then also, subsequent to making that e-allegation, submit to CBP what is called a Form 4623, then you are eligible for a reward if CBP ever recovers money as a result of the information that you've provided. The Enforce and Protect Act, EPA, has a very, very similar procedure, except it's more limited in what it covers. It only applies to AD/CVD orders, and only people that are affected directly by the violation are eligible to bring EPA claims. So that's typically members of the affected industry or unions representing employees within the affected industry. So it's a smaller group of sort of entities that can bring these EPA claims. Now, these e-allegations and EPA claims have some upside, which is that they're very simple to initiate, but they have some significant downsides relative to bringing a key TAM case under the False Claims Act. For one thing, there's a $250,000 cap on the reward that you can bring if you follow one of these paths, as opposed to bringing a key TAM case under the False Claims Act, where there are no caps, and where we just saw from the statistics, the average award is close to more than $500,000, and there have been awards in customs key TAM cases that are multi-millions of dollars. So if you have information about a fairly large fraud that could potentially generate a reward of greater than $250,000, you're better off following the False Claims Act key TAM route than you are filing an e-allegation or an EPA claim. The other downside to e-allegations and EPA claims is they are purely administrative procedures that are run by CBP. There's no court involvement, and they are kind of black box procedures. The person submitting the e-allegation, for example, won't really know what CBP is doing with that information, and you are relying on CBP to sort of honestly tell you if and when they ever recover any money based upon your information that you've submitted through the e-allegation. So it's a bit of a black box. you won't know what's going on with your information. You won't know if and when it actually results in recovery that could entitle you to a reward. And so you're really just waiting for CBP to act, and you are trusting that CBP will do what it is supposed to do. Contrast that with a key TAM case brought under the False Claims Act, which is a lawsuit filed in court. There is a judge there overseeing that case that you can go to if there's any issues. You have a Department of Justice attorney assigned to the case who your attorneys can communicate with directly about the status of the investigation. And so there is some back and forth where the Department of Justice will periodically tell you what is happening in the investigation. And there is basically no chance that they could settle that case or recover money without you knowing about it. So you're pretty much guaranteed a reward at the end if, in fact, the government is able to recover money. So it's a much more open process. And again, you've got a federal judge overseeing the case. If there are any issues, somebody that you can go to complain to, and that's important, keeps the government honest. So, except in relatively small, simple cases, we generally recommend that whistleblowers or other entities, insiders or outsiders, that they avail themselves of the key TAM route as opposed to the e-allegation route. So that is my last slide. Now I'm going to put up my contact information here. And so if you want this, write it down because I'm going to stop sharing my screen shortly and move on to questions. But there it is. That's me. That's my email address. That's my direct dial phone number. So if you have any questions, follow-up questions that you want to ask, please feel free to send me an email, give me a call. I'm always happy to chat about these things. I promise I will not send you a bill for my time. This is just part of my business, and I'm more than happy to talk to people about issues, answer questions. Our firm has a website, fraudfighters.net, that is all things whistleblower. It's not just about customs, although there is quite a bit of information about customs cases on that website, but it covers the False Claims Act more generally and other types of whistleblower statute as well. So there's lots of useful information on there. And we post about news items that relate to this area of law. So if you are interested in that, check out our fraudfighters.net website. Okay, I'm going to stop sharing my screen, and then I'm going to turn to some questions that folks have submitted. So first, somebody asks, can you bring a key TAM case under the False Claims Act if you are not in the United States? Yeah, that's a great question. The answer is yes. There's nothing in the statute that says a relator needs to be a U.S. citizen or a U.S. resident or physically located in the United States. So if you're somebody in a foreign country who has information about fraud on the U.S. customs system, which you might be if you work for, say, a foreign manufacturer that is exporting to the United States, then you can be a relator in a key TAM case, and you can earn a reward under that statute the same as somebody who is a U.S. citizen or resident. The next question is, how long do key TAM cases normally take before you earn the reward? Yes. Well, so on one of the slides you saw that I put up that the average seal time, which is the amount of time it takes for the government to complete its investigation, is about 18 months. However, that average includes cases that get resolved very quickly because the government very quickly determines that they are meritless, that they are not going to succeed. Maybe somebody files a case, the government looks at their own data and says, well, the company actually has paid the duties, or something like that. And those cases go away very quickly. The cases that are successful almost always take longer than that. The average is closer to 2.5 to 3 years from the filing of the key TAM case till the resolution of the case in cases where the government intervenes. In cases where the government declines, I can't even give you statistics, but it would be that plus whatever time it takes to actually then litigate the case if you are the relator. So the upshot is if you file one of these cases, you need to be prepared to wait at least 2 or 3 years before you are going to get to the end to get to a successful resolution. And in some cases, it's even longer than that. I mean, obviously, as the lawyers representing the relators in these cases, we do everything we can to move the cases as efficiently and quickly as we can. But a lot of it just depends on the pace of the government's investigation and the government's actions. We have limited control over that. And unfortunately, the government moves at government speed, which is not quick. Okay, here's one of my favorite questions that I get is, how do you find a lawyer to represent you in one of these cases? So, well, you can call me, but there are other lawyers like me who sort of have a specialization of representing relators in qui tam cases. And all I would say is find one of those lawyers because the False Claims Act, it's very different than other types of litigation. We talked a little bit about the seal period and some of the other special procedures that make qui tam cases different than normal civil cases, but there's a lot else to it. Representing a relator in a qui tam case, the lawyer is spending a lot of time dealing with the Department of Justice lawyers who are handling that case and the other government lawyers and investigators that are working that case. And sort of knowing how to do that is something that you sort of figure out through experience, and you sort of learn who the players are and kind of how to work that system to try to move the cases forward quickly and try to move the cases forward to a successful conclusion. So, what I would recommend is definitely look for a lawyer who has experience handling qui tam cases. There aren't a lot of us. This is sort of a very niche practice. There's probably only about 500 of us in the whole country that really do this as a significant part of our practice. But try to find one of those folks, and you will be well served by having done that. All right, looks like we've got one more question, which is who can be a defendant in a qui tam case? Excellent question. So I had a slide talking about who the relators can be, but I did not have a slide talking about who the defendants can be. So in a qui tam case involving customs fraud, the most obvious defendant is going to be the importer of record, the company in the United States that is acting as the importer of the goods. They are the entity that is directly liable for customs duties. And so they are the most obvious target of a qui tam case. But there are others because the qui tam statute, the False Claims Act, provides liability not only for direct violations, but for what are called causing violations. So if one company causes another company to violate the False Claims Act, that first company could also be liable. So imagine a situation where you have an overseas company that is selling to a US customer, and that overseas company is lying about the country of origin of the products it is selling. That overseas company could become liable for the customs violation in the United States, even though they are not the importer of record. And you could also have downstream customers. So, for example, let's say you have a retailer in the United States that wants to sell a product, but is trying to keep their costs down. And so they convince some other company to import products that have been transshipped as a way to avoid paying some duties. That downstream retailer, if they were sort of involved in something that looks kind of like a conspiracy to evade customs duty, the downstream retailer might have liability. So there's lots of different entities, the overseas entity, the importer of record, downstream retailers who might, depending on the facts, have liability under the False Claims Act and who could be named as defendants in a qui tam case. Also, there could be individuals, let's say the owners of the importer of record. Under some circumstances, if those owners were themselves, say, directly involved in or directing the fraud, they could have individual liability under the False Claims Act as well. So sometimes you see cases where a relator has named multiple different defendants. They've named the importer of record in the United States. They've named an overseas company, but then they've also named some individuals who were directly involved in sort of perpetrating the fraud that's being alleged in that case. And sort of figuring out what the right constellation of defendants is, that is, something that we do as the lawyers with our clients' help to try to figure out kind of, not only is there a violation of the statute, but who could potentially be liable for that violation if we were to bring a case. So it looks like that's all the questions we have. Uh, and in light of that, I'm going to give you your 12 minutes back. I hope you have enjoyed this presentation and learned something from it. Again, I'm John Tycko, and please feel free to reach out to me with any questions or comments, or if you want to talk about anything covered by this or other issues relating to whistleblowing. I also just want to say thank you to our firm's marketing director, Q Maselli, who helped me put together the slideshow and put together the presentation today. So thanks a lot, Q. And with that, we will say goodbye.